Honorable members, there will be now an opportunity for silent prayer or meditation. Please be seated. Honorable members, I have received the request that precedence be given to order number 3 immediately after the motions, and further that the legal practice bill number should read Bill 20D 2012 instead of Bill 20B 2012. Does any member wish to give a notice of a motion? None. Does any member wish to move a motion without notice? Honorable Sinclair? Yes, sorry, Honorable Sinclair. Honorable de Villiers?
Chairperson, thank you very much. Just on a point of order, we as the whips didn't receive any information that this afternoon will there be motions, and we did not also make that decision in the whips forum meeting. That is due to my information.
Chief Whip.
Thank you, Chairperson. I don't know what happened. You should have been informed that you agreed that there won't be motions today. I apologize for those who have.
Okay. Okay, Mr. Willis. Mr. Sinclair, you can continue with your motion.
Honourable Chairperson, so you actually say I'm the only one that's right today?
I couldn't hear that. Oh, okay.
No, Chairperson, I'm just on a lighter note, says that it seems that I'm the only one that's right today.
Oh, okay. Continue.
Thank you. Thank you. Honourable Chairperson, I move without notice that the House firstly notes the cellular company wars going on in the media between the major operators in the country on pending regulations on asymmetric costs, now including Telkom joining the fray. Secondly, acknowledges the open letter written by the Telkom CEO to the other operators, alleging that the other operators are hiding behind regulation to protect profits, thereby holding back the country in the required access and expansion of technology in the industry. Thirdly, Honourable Chairperson acknowledges that growing wars and tension and the subsequent lack of ICASA to act decisively in this instance is disadvantageous and costly to users and subscribers of these network providers. And lastly, recognizes the sooner there is transparency in the proposed regulation for these termination rates are implemented, the better it's for pedantic technological development in this country. I so move.
Any objection to the motion? Agreed to in terms of Section 65. Any further motion without notice? No. We then proceed with the order paper. We now come to the motion on the order paper as printed in the name of the Chief Whip.
Thank you, Chairperson. Chairperson, we want to move a motion that Rule 2391, which provides inter alia that the consideration of the bill may not commence before be suspended for the purposes of consideration of the following bills today on Wednesday, the 5th March. Legal Practice Bill, Judicial Matters Amendment Bill, and Private Security and Industry Regulation Amendment Bill. I so move, Chair.
As there is no speakers list, I shall now put the question, and the question is that the motion be agreed to. As the decision is dealt with in terms of Section 65 of the Constitution, I shall first ascertain whether the delegation heads are present in the chamber to cast their provinces' votes. Are you all present? Yes. In accordance with Rule 7.1, I shall first allow provinces. Honourable Liz.
Honourable Chair, thank you very much. On a point of order, Honourable Chair, Rule 2391 has two sections to it, that a bill has to fall in line with either A or B. A says unless the bill is before the House in terms of Joint Rule 216, or it's an urgent bill. Could we please be informed whether indeed this is an urgent bill? And if so, on what are these three urgent bills? On what basis are they urgent?
Well, I've put the question now for a decision. In accordance with Rule 7.1, I shall first allow provinces the opportunity to make their declaration of votes. Is there any province that wish to do so?
Yes,
Mr. Villiers?
Yes, Chairperson. Must I go there, or can I stand here?
Anyway.
Okay, thank you very much. Chairperson, the Western Cape is actually against the motion on the order paper due to the following reasons. That in relation to the three bills on the order paper, there is nothing urgent, and the three bills are not threatened by time. And therefore, it is not necessary to put this motion on the table to handle these bills on the order paper. Thank you.
Okay. Any other province that want to make a declaration? None. You all happy about it? Are you happy about the motion? Okay. We will now proceed to the voting to the question. Heads of delegation will vote in favor, against, or abstain. Will use your system to vote. The voting has commenced. The votings, all right, let's use the manual. I see, all right. Eastern Cape, have you voted? You are okay. Free State, you are okay. Vote in favor, Gauteng? In favor? KwaZulu-Natal is not here. Limpopo, in favor. Mpumalanga, in favor. Northwest, I'm sorry, Northern Cape, Northwest, Western Cape.
Western Cape, I voted, Chairperson. Western Cape.
Western Cape, you voted. Mr. Liz, what's happening?
I'm not getting the voting, so I need to vote manually, Mr. Chairman.
No, you're not the head of a delegation, isn't it?
Mr. Chairman, I'm the only delegate today, so...
Okay, the staff will give me the results. Order, 7 provinces voted in favor and 1 province, which is Western Cape, voted against. Therefore, the motion is agreed to in terms of Section 65 of the Constitution. The Secretary will read the third order of the day as agreed earlier on.
Consideration of Private Security Industry Regulation Amendment Bill, Bill 27D of 2012, and of report of Select Committee on Security and Constitutional Development thereon.
I'll now call upon Honorable Mofokeng.
Thank you very much, Chairperson. The Private Security Industry Regulation Amendment Bill provides for the regulation of a private security industry in order to give effect to the White Paper on Peace and Security to strengthen the legislation and regulatory framework of the private security industry. It also regulates security services rendered outside the Republic and sets out offences and penalties in this regard. The bill proposes extensive amendments to the Principal Act in order to address shortcomings in the Principal Act and align it with the Constitution as well as the Public Finance Management Act. In order to give the objective of regulating the private security industry, the bill also proposes amendments to certain definitions, assigns additional powers to minister. These powers include ministerial supervision of the authority, filling a vacancy on the council, suspending or removing any member of the council from office, as well as mediating in the event of a dispute between the council and its members. Council members must be South African citizens and must obtain security clearance by the National Intelligence Agency. Other matters covered by the bill include the registration of security service providers and their members. However, it is possible to apply for an exemption advisory committee in this regard. The bill places a restriction on foreign ownership in private security business and requires that 51% of ownership must vest in South Africans. The provision was extensively debated in the Select Committee, and the Democratic Alliance and some submissions were of the view that this will have a negative impact on foreign investment and is in contravention of the South Africa's obligation under World Trade Organization's General Agreement on Tariffs in Services. However, the majority of delegates were satisfied with the department's responses that the agreement allows a certain exceptions, which include national security considerations. The Select Committee on Security and Constitutional Development reports that it has considered the bill and that recommends that the Council passes the bill. I thank you.
That concludes the debate. I shall now put a question, and the question is that the bill be agreed to. In accordance with Rule 6.3, I shall first allow political parties to make their declaration of vote if they so wish to do so. This is a 75 bill. Is there any province that wish to do so? Honorable Liz? Not province, I'm sorry. Political party. DA, Mr. Liz?
Honourable Chair, the DA wishes to make a declaration, and it will be made by Honourable Boshoff, and then we will call for a division.
Mrs. Boshoff?
Honourable Chair, thank you very much. The DA maintains that the passing of the Private Security Industry Regulation Amendment Bill will have detrimental consequences for our economy and cause our country's unemployment to soar. This, in addition to various other reasons, is why we oppose the bill. The DA believes that the reintroduction of Section 22C, which seeks to restrict foreign ownership in the Private Security Industry Regulation Amendment Bill, will constitute an unlawful expropriation under Section 25 of the Constitution. This controversial bill allows for the state to expropriate at least 51% of any foreign-owned security-related company. It has also been noted that the bill further allows for 100% expropriation at the discretion of the minister. It is the DA's belief that the reintroduction of this clause at a time when our rand is in a sustained weakness against major global currencies, and when analysts are stating that ours is one of the hardest hit currencies in the emerging market, will have catastrophic consequences for our economy and investor confidence. Furthermore, Mr. Chair, additionally, we believe it may also place the government in breach of international trade agreements, specifically the World Trade Organization General Agreement on Trade and Services. The DA is also concerned that the members of the National Assembly Committee were not able to fully apply their minds to the reinsertion of Clause 22C on the last day of their deliberations, and that several submissions from foreign states were withheld from the committee by the chairperson. Because of the failure of the Portfolio Committee to take into consideration the views of certain foreign states relating to South Africa's obligations contained in existing international agreements, the DA believes that the bill should have been returned to the National Assembly
Order.
for further
Order, Mr.
deliberations.
Bishop. Honorable,
Chairperson, if I may be assisted, in that the honorable member is referring to the decisions that were made in the National Assembly. Is it correct to do that? Because we are now dealing with the bill in the National Council of Provinces.
did you refer to the NA, Ms. Bishop?
Yes.
If you refer to the NA, that has got nothing to do with this House. They do have their own deliberations, and you all have your own deliberations.
Thank you, Mr. Chair. I will retract that. The bill is discriminatory and unconstitutional. It will harm investor confidence, batter our already ailing economy, and ultimately result in job losses. It will also place an added burden on the South African police services and therefore undermine the fight against crime. The DA therefore opposes the bill. I thank you.
Honorable Matila.
Thank you, Chair. Chair, as the African National Congress, we support the bill as debated and deliberated on in the committee. The problem that we are faced with is in the committee, the member who just made that particular declaration never raised the issues he has raised now. You see, the problem is somebody else write these things for them. They agree with us in the committee at some point. But the point I wanted to raise, Chair, is that the reality of the matter is the DA can be a representative of the international community, of Europe in particular. We have indicated that in Africa, in Europe in particular, whether in America, whether what we are trying to do in this particular law,
Honorable Liz.
Honourable Chair, on a point of order, the Honourable Member Matila is misleading the House. The questions that were contained in the declaration were raised at the committee. In fact, it was recorded as a minority view, and the Honourable Member who made the original declaration actually stated that the DA had made that. So I would request that that be withdrawn, please.
Chair, can I respond that the honourable members did not raise it in the committee? They came to another committee to come and raise a declaration. We concluded the bill. We concluded everything in the committee. When we're dealing with a second bill, then they came with this particular declaration to the committee. And we then said, no, we can't discuss this declaration. And that's the point we have raised to them, that they come with an assigned document. No? Whoever has written that particular document, we don't know who it is. No? And they wanted to sign that document in the committee. We then said, no, we can't discuss this particular matter. We have made it very clear to them. And they started signing that document in the committee. We said, but the first meeting that concluded this particular bill, we can't reopen that bill because a report has already been written. It's finished. It's closed. It is unfortunate that when they came in later, we don't know who they spoke to, who. In the committee, it was never raised. We want to make it very clear. Now, in the committee that took that particular decision, the DA did not raise anything else. They only said they vote against the bill, but they did not do anything else over than that. But let me continue with the declaration, Honourable Chair.
Your time is running out.
Yeah.
Let me answer Mr. Liz first. Honorable Liz, Ms. Poshoff retracted what was said in the NA, so I do not know what happened in the committee. If that is the case, we'll relook at the minutes of the committee. One can rule in the next sitting of the House.
Yeah. Thank you, Chair.
Okay. Just
Now-
finish up.
Now,
Mr.
Chair,
Martin,
let me
and
finish
continue.
up.
Yeah.
The point we're raising is that the DA wants to take us back to apartheid time. What they are trying to do is to make sure that everything else is owned by Europe and white people. Now, the issue we're saying is Africans and South Africans. When we're saying South Africans, we're meaning everybody else must deal with this particular situation, you know? And that is the point we're raising, that when you go to each and every country, whether it's London, whether it's Kenya, whatever, what you find there is the private security is in the hands of those particular people, and nothing like foreigners. In this country, what is worse, these particular companies employ more than 60 to 70% of foreign people that came in illegally, which is a problem to this particular country. It is a risk to the security of the country, and the DA wants that because it's in their interest. Thank you very much.
Mr. Liz, did you call for a division? Yes, Chair. Okay. Yes, hang on. Let me sit down. Take your seat. Don't be in a hurry. Let me hear Mr. Mashila first.
Yeah, Chairperson, I really have a problem.
Yes.
Because we thought that the DA is led by De Villiers this side, but today it looks like Mr. Lees is a conductor of the activities of DA.
No, this
And
is a
putting preambles.
75 bill. It doesn't matter. It's not a section 65. All right. Oh, okay. All right. Okay. We now come to voting because the division has been called. Just sit where you are, use your electronic voting. You can either vote yes, abstain, or what is the other one? Not in favor of the bill. The machine will record and then we'll get the results. Mr. Liz?
Just for clarity, Honourable Chair, the names will be recorded of who votes for and against. Is that correct?
Let me just check with the staff. Yes, I'm told the machine will record your name and the vote. Yes. Order, let's continue. The vote has commenced. Those who might have voted wrongly, please correct your vote. The vote is concluded. Have everyone voted? Right, vote has been concluded. I will ask for the results from the staff. Okay, I've got the results. Those in favor, 20, against, 9, abstain, 1. I therefore declare the bill agreed to in terms of Section 75 of the Constitution. The Secretary will read the first order of the day.
Consideration of Legal Practice Bill, Bill 20D of 2012, and of report of Select Committee on Security and Constitutional Development thereon.
Honorable Mufokeng.
Thank you very much, Chairperson. The Legal Practice Bill is intended to address the following: to rationalize the current fragmented legislative framework in terms of which the former Republic and former Homeland laws still in operation in various parts of the country will be repealed and replaced by a single statute regulating the profession in its promote and protect the public interest, establish an Office of Legal Service Ombud, and make the legal profession more accountable in terms of the disciplining of legal practitioners. The members agreed that the department had satisfactorily answered the amendments and concerns raised in the province's negotiating mandates. The members further agreed that the department must amend the bill accordingly and effect consequential amendments. And the following provinces voted in favor of the bill: the Eastern Cape, Free State, Gauteng, Limpopo, Mpumalanga, Northwest, Northern Cape, and the Western Cape recorded their opposition to the bill, and KwaZulu-Natal abstained from voting. The committee consequently recommends that the Council approve the legal practice bill. Thank you.
That concludes the debate, and I shall now put a question, and the question is that the bill be agreed to. In accordance with Rule 7.1, I shall first allow provinces the opportunity to make their declaration of vote if they so wish. Any province that wish to do so?
Yes, Chairperson.
Honorable de Villiers?
Yes. Honorable Becker will...
Honorable Becker?
Declaration, Western Cape, on the Legal Practice Bill. Regularity reform of the legal professions has been happening in many common law countries in recent years. The reasons are always the same: affordability and access, choice, competition, and consumer protection. These are the same problems we should be addressing. Instead, what is South Africa doing? The Legal Practice Bill forces advocates and attorneys into one governing body, the Legal Practice Council, and put the attorneys in charge. It is thus fusion in disguise. The Western Cape proposed a variety of changes to the bill. Of main concern is the formation of the Legal Practice Council. We propose rather that there should be two separate chambers for advocates and attorneys at the national and regional level. Our second main concern with the bill is the areas of the bill which give the Minister of Justice too much power of the South African Legal Practice Council and over the profession as a whole. These include the power to appoint members to the interim council, which will have a major impact on the final council. We also believe that decisions regarding community services should be done in consultation with the council and not after consultation, as the bill states. Finally, the Minister has the power to dissolve the Council. We believe that no such power should exist, as it is incompatible with the independence of the legal profession. As such, we believe that the bill will fail to address the crucial issues of access to justice and will impact on the independence of the profession. We oppose.
Any other province that want to make a declaration? Honorable Mukhobi?
No, not declaration. I want to stand on behalf of the ANC. Is it a declaration?
No, I'm calling provinces. This is a 76 bill.
Oh. Can I do it?
Yes.
Thank you, Chairperson. As Limpopo, we are saying the bill is very important to be passed by this House, precisely because we are dealing with the patterns of briefings in the South African judiciary. If you look into the processes, African in particular, blacks in general, they are not having access to the current system of briefing. And therefore, this bill wants to deal with the question of equity so that all South Africans in the judicial system are getting the right briefing from everyone who has got access to law. We are trying to say, to follow the freedom charter clause that says all shall be equal before the law. We cannot be satisfied at the current situation wherein the judicial system is being run. If we are saying all shall be equal before the law, we mean that all South Africans from non-racial context, black and white, not black only, not white only. As our former late president has said, we have fought against black domination and we have fought against white domination. And therefore, this legal practice bill is welcomed. It must be voted, not only by the provinces, but everyone in South Africa, black and white. Thank you.
Mr. Liz?
Honourable Chair, thank you. I note that both the members who made declarations neither of them were heads of delegation, and therefore I request that I make a declaration on behalf of KZN.
No, the issue here is that I have been informed by the leaders. Mr. de did declare that he delegates Mr. Becker to make a declaration. Same with Mr. Mukhobi. I've been informed that he will be making on behalf of Limpopo. I didn't get any from the heads of delegation from KwaZulu that you can make a declaration.
Thank you, Mr. Chair. I'll have to speak to my leaders.
Thank you. Honourable members, that concludes. We shall now proceed to the voting on the question.
Chairperson,
Yes, Mr. Honourable Sinclair.
I just want a question of clarity. I understand that the KZN provincial legislature is today having its opening ceremony. I just want to find out why the Honourable Lees is not there.
I don't know, Mr. Sinclair. Maybe you can have a chat with Mr. Liz. Okay. We shall now proceed to the voting on the question, and we'll use our electronic voting system. Heads of delegation, vote in favor, against, or abstain. Voting has commenced.
Can they get the gadget right? The gadget is still dead.
The gadgets, please reactivate. Are they dead?
Yes. No, they are dead. I'm sure they ran out of shells.
All right, Eastern Cape? Yes. Free State? Vrystaat? You are busy talking. Yes. Gauteng? You voted yes. Kuluma ke baba, kuluma sis.
Voted yes.
Yes. The head of KwaZulu is there, Limpopo? In favor? Mpumalanga? In favor? Northern Cape? In favor? Northwest? In favor? Western Cape? Against.
Please note that Eastern Cape, KZN, and Free State did not submit mandates, so we cannot take pre-voting. So it's only six.
Whoa. No, man. It Isn't it true? He said yes. Okay, I will check. I will check. And I will say to her, it's you.
Here are the results. Those in favor, 5. Abstention, 1. Those who did not submit their mandates are 3. Therefore, 5 provinces in favor, that's what I've said. 5 in favor, 1 abstained, 3 did not send their mandates up to so far. Therefore, the bill has, 5 provinces have voted in favor. The bill has been agreed to in terms of Section 65 of the Constitution.
Western Cape against not abstain.
The Secretary will read the second order of the day.
Consideration of Judicial Matters Third Amendment Bill, Bill 53 of 2013, and of report of Select Committee on Security and Constitutional Development.
Honorable Mufokeng.
Thank you, Chairperson. The bill seeks to address the practical and technical issues on a non-contentious nature by proposing amendments to the Attorneys Act number 53 of 1979 and the Child Justice Act number 75 of 2008. Namely, in the Attorneys Act, the bill seeks to regulate the powers of the Board of Control of the Attorneys Fidelity Fund in order to stem the increase of theft committed by attorneys for which the fund becomes liable to pay. Secondly, amendments are proposed to the Child Justice Act regarding, among other things, the proof of criminal capacity of children who are 10 years or older but under the age of 14 years and who are alleged to have committed an offense. Currently, an inquiry magistrate or child justice court, when making a decision regarding the criminal capacity of a child, must consider the assessment report of the probation officer and all other evidence placed before the court, which may include a report of an evaluation done by a suitably qualified person. The bill will now require the inquiry magistrate or child justice court to consider the cognitive, moral, emotional, psychological, and social development of a child on the basis of all evidence placed before the court. The relevant section on the Child Justice Act is thus amended to include different classes or categories of persons who may be determined for the purpose of different aspects of development of a child. The bill also allows the Minister of Social Development to delegate to the provincial level certain powers relating to the accreditation of diversion programs and diversion services providers in terms of Child Justice Act. The final amendments proposed by the bill seeks to give effect to the recent decision of the Constitutional Court in which it declared certain provisions of Section 51 of Criminal Law Amendment Act unconstitutional, and that children who were under the age of 18 years at the time of the commission of an offense must be excluded from the Act's operation. The committee recommends that the council pass the bill. Thank you.
That concludes the debate. I shall now put a question, and the question is that the bill be agreed to. According to Rule 7.1, I shall first allow provinces the opportunity to make the declaration of vote, if they so wish. Any province that wish to do so? No. We shall now proceed to the voting. Heads of delegation, please use your electronic to vote. Press the button in favor or against or abstain. Voting has commenced. If your machines are not working, we'll take it, we'll do a manual voting. Should we take a manual voting? Yes. Eastern Cape? Abstain. 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 Eastern Eastern Cape abstain. Excuse. Oh. Okay, Free State? No. Yeah, Eastern Cape Free State.
In favor, Chair.
Gauteng?
Sivotile.
Vote njani?
In favor.
Limpopo? Mpumalanga? Northern Cape?
Northern Cape, vote in favor.
Northwest? In favor, Chair. Western Cape?
In favor, Chairperson.
In favor. I will ask for the results. Six provinces have voted in favor. I therefore declare the bill agreed in terms of Section 65 of the Constitution. Honorable members, that concludes the business of the day. Yes, Mr. Villiers.
I just want to bring something to your attention, that on the legal practice bill, I did vote on the system, and it wasn't recorded, and I voted against it.
Is it?
You didn't say so, I missed that.
It is recorded against.
Is it a
Yes.
Thank you very much.
It's recorded. That concludes the business of the day. Honorable members, you are requested to remain standing until the procession has left the House. The House is adjourned.